What is a refusal and what are the consequences? In the state of Utah, we have what's called the implied consent law. Virtually every state has an implied consent law with similar provisions. In the state of Utah, our implied consent law says that any person who operates a motor vehicle within the geographical boundaries of the state of Utah consents to a chemical test, whether it be blood, breath, or urine, if an officer believes or has reason to believe that you're driving under the influence. Pursuant to Utah's implied consent law, it is the officer that gets to choose which chemical test you take. It is not up to the driver. Likewise, the officer can request multiple tests, meaning that the officer can request a blood test, a urine test, or a breath test. The officer can request blood and breath. The officer can request breath and urine. The blood test and the breath test are adequate for determining breath alcohol or blood alcohol content. However, a breath test is unable to determine the presence of drugs. Therefore, oftentimes officers will ask for a combination of these two tests. Now, if you're asked to take a chemical test, the implied consent law says you will agree to take that test. And if you don't agree to take that test, you will actually be subject to some very serious driver's license consequences. On a first refusal, with a first DUI offense within a period of 10 years, if the individual refuses to take the breath, blood, or urine test, whatever the officer requests, they will be facing the potential of an 18-month driver's license suspension with no limited driving, no work permit whatsoever. They'll also be facing a 3-year ignition interlock restriction, which means they cannot operate a vehicle without an ignition interlock device installed. A refusal can be taken from basically anything other than your acquiescence to the test. If the individual says no, that's a refusal. If the individual refuses to blow into the machine properly, that's a refusal. If the individual does not allow them to draw blood or take a urine sample, that's considered a refusal. Refusals are very seriously punished. Therefore, when deciding whether or not to take the chemical test, you certainly have to keep in mind how important your driver's license is. If this is your second DUI or alcohol-related driving offense or your second refusal within a 10-year period, you will be facing a 36-month driver's license suspension, again with no option for work permit or limited driving privileges. In addition, for a second refusal, you will become an ignition interlock restricted driver for a period of 6 years, and you will become an alcohol restricted driver for at least 10. So as you can see, the consequences for refusing to submit to a chemical test are quite severe. However, keep in mind that you do not have to submit to a roadside portable preliminary breath test. These are the small handheld breath tests that the officers may try to give you as part of the field sobriety test sequence. However, the implied consent law only is invoked after you've been placed under arrest and then requested to submit to a chemical test.